Money Radio, thank you for joining us. It's time to talk real estate with Laura Bramnick from TalkRealEstateAZ.com. Laura is an attorney. She's a real estate agent. She's also a consumer advocate, and she helps represent people in residential, commercial, or land transactions and really make sure that you have a concrete plan to work on.
Yes.
That's important.
That's very important.
A lot of people think they have a plan and maybe don't.
Yeah, they don't really investigate all the possible consequences, and sometimes they rush through because they get excited and they think it's a good deal.
I want to talk with you about that. Let me give out your contact information first, though. TalkRealEstateAZ.com, that's your website.
Yes.
Folks can even see videos of you and I as we get together on Thursdays.
Yes, they just don't hear our lovely voices. They can actually watch us in action.
TalkRealEstateAZ.com. You can call Laura, 480-624-2705, 480-624-2705. Laura answers her own phone. Laura is an attorney specializing in real estate, also a real estate agent. It's a twofer.
It's a twofer.
We talked last week about holding deeds. There are different ways that you can hold title to a property.
Yeah, we talked specifically about joint tenants and beneficiary deeds, but today I want to talk more about disclaimer deeds, tenants in common, different situations that come up that people need to be aware of.
Disclaimer deed, that's where somebody signs away what might be a right to a property. And I'm thinking, this is a community property state, so
Right.
you have a husband and wife, and one of them buys property, the other one, for whatever reason, does not want to be included on that property.
Yes, so when a spouse wants to buy a property, what they call sole and separate,
Mm-hmm.
the spouse that is not going to be on title needs to technically sign off or sign a disclaimer deed. And
Why would they do that?
they would do that because any property acquired during the marriage is technically community property. There are some exceptions to that.
Mm-hmm.
But the general rule is that when you acquire property during the marriage, and I have this come up a lot, like when people are separated,
Right.
and many times they're in the process of divorce, and one party's moved out of the house and wants to buy another property, doesn't want to rent. And if it's not a relatively smooth divorce, if it's contentious,
Right.
the other spouse will refuse to sign, because they don't want to cooperate with the spouse that's moved out. So this comes up in that situation. It also comes up, I have a lot of clients who maybe their mother is a surviving spouse. Their father died, their mother owns and lives in the family home, and she wants to, maybe she has an only child, she wants to add his name to the property, but if that child is married, maybe doesn't want his wife or husband on the property.
Right. Okay.
So that's pretty common as well, and so in order to do
So it comes up in
that,
divorces,
yes.
It comes up in issues of inheritance or passing along property.
yes, and so you can't just purchase a property if you're married and have your spouse waive. They have to actually sign a document that's recorded and notarized, so you need their consent, in other words.
Okay, I would think another area might be if it's a business deal and one spouse has set up a partnership or
Yes.
some sort of relationship with other investors.
That's also very common. And, people may have a corporation or LLC, but if they don't, and it's purchased during the marriage, they have to sign off.
Okay.
So
the disclaimer deed basically solves the problem?
yes, it most of the time. There's all, as you know in the law, it always depends. But yes, for the purposes of our conversation, that solves the problem. Now, what happens, and also if you buy property and you're tenants in common, so that if one of you dies, the property doesn't go to the survivor. It goes to the person who died. It goes to their estate.
Right.
But what if they died without a will?
Intestate.
Intestate. Now, even though their, let's say in this case, wife signed off, she's the one that's going to inherit your share of the property. So it gets kind of
So even
complicated.
if there was a disclaimer
Right.
deed and someone dies intestate, it could still come into play.
Yeah. Now, let's say that your dad died and your mom wants to purchase property and she wants to put your name on the deed when she purchases it, and your wife signed off, and then but you didn't hold it as joint tenants, you held it as tenants in common for whatever reason. If you didn't have a will or a trust, even though your mom didn't want to own that property with your surviving wife, she's going to.
So the disclaimer actually applies at the time it's signed, but not necessarily waiving future interest.
It does not waive future interest in this instance of intestate succession, because you're waiving your right currently to that property. But when the ownership changes, the law specifically states that the disclaimer deed does not carry forth to the inheritance.
See, now this is an area where somebody could get easily tripped up.
Yeah, and it's not that common, but you want to know if you're trying to avoid one of the parties inheriting property, you could kind of shoot yourself in the foot if you don't dot all your I's and cross all your T's.
Really, passing along real estate as part of a legacy, the inheritance of property,
Right.
is an important issue for many families.
Yeah, you can do it by beneficiary deed, joint tenants, or if it's tenants in common, the party just needs to have a will or a trust.
Yeah, but you really have to understand some of these little things that could trip you up if you're not careful.
Exactly.
You may think, oh, well, I'll just have a disclaimer deed signed, and that solves everything. Maybe, maybe not.
No, right.
That's why you really should be involved in any transaction where they're trying to set something up for passing it on in the future, or for that matter, as you say, something like a divorce. It can get quite tricky.
It can get very tricky. And people, as you know, have very specific ideas about how they want to leave their property.
Yes.
Because to some people, being a tenant in common is very important as opposed to being a joint tenant. And they want to take control over their share of the property.
That's right. Laura Bramnick from TalkRealEstateAZ.com. TalkRealEstateAZ.com. The devil is always in the details, and that's why it's so important to talk to Laura, especially when there's a situation that involves an inheritance, divorce, and real estate. 480-624-2705. If you have a question, Laura answers her own phone. 480-624-2705. Thank you, Laura.
Thanks, Sinclair.